Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as the coordinator for today's program. So we're going to attempt to cover the proverbial avalanche of employment law changes you've all been reading about. And they're certainly challenging employers, and they're also challenging our own attorneys to keep up on all the updates. So we're going to do our best to convey as much information as possible during our 1 hour time block and have time left over for some Q&A. Fortunately for us, we have today with us Laura Dinan from our Petoskey, Michigan office and Rhonda Stowers from our Flint, Michigan office. Both are very experienced employment attorneys, and they'll, again, do their best to help us dig out from under this avalanche of changes. Before we get started, I'd like to take a few moments to provide you with some background about today's speakers and about our law firm. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 130 attorneys. We have 7 offices in Michigan, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our labor and employment group includes attorneys who work primarily in the areas of traditional labor law, human resources consulting, investigations, and employment litigation. I'd also like to point out today's webinar has been approved for 1.25 general recertification credit hours through the HR Certification Institute, that's a mouthful, and 1.25 professional development credits through SHRM. Following today's program, a certificate of completion will be emailed to each of you reflecting this credit. If you don't need CE credit, simply disregard the certificate. At this time, I'd like to introduce our speakers. As I mentioned, Laura Dinan and Rhonda Stowers are with us today. Laura has been practicing for over 30 years now, and she has experience advising employers of all types of workplace-related issues. She's built a successful practice representing public and private sector employers of all sizes throughout northern Michigan. Laura's expertise includes consulting on employment law issues, administrative hearings, traditional labor, and litigation. She's a current board member and a past president and past secretary of the board of directors of the Northern Michigan Society of Human Resource Directors. Rhonda works with some of the nation's leading insurance providers to defend employers who have become entangled in litigation. Her practice includes private and public sector clients, including numerous municipalities. She has particular experience with the defense of discrimination and retaliation litigation under various statutes, including the Americans with Disabilities Act, Michigan's Elliott-Larsen Civil Rights Act, and the state's Persons with Disabilities Civil Rights Act, among others. Just a couple of quick housekeeping notes, and we'll get started. For the Q&A portion of our webinar, we're going to use our questions widget on your GoToWebinar navigation dashboard. If you could just take a minute to find that, go ahead and ask questions as they occur to you throughout the program. We will get to that Q&A at the end, however, because we have so much material to cover. The only caveat I always like to add is just don't, in asking your questions, don't ask too much, don't provide too much detail that would give away your company name and any specifics. We don't want to, we want to keep it somewhat generic if we can. Finally, I just want to mention that today's session is being recorded, and that recording will be available on the event page of our website, which is plunkettcooney.com. Feel free to share a link to the recording to your colleagues so that they get this valuable information as well. At this point, I just want to say thanks for attending. Laura, I think you are up first, so please take it away.
Thanks, John. Thanks, everybody. We're happy to have you. I just want to start out by saying this is an amazing amount of cases and regulations are coming out right now that affect employers. We've tried to cover everything that we're aware of, at least to alert you to the issues that are out there. There's a lot more to come, and honestly, we're probably going to have to do this again in a few months when the cases have been decided, as they go up on appeal, and as laws and rules get out of the proposed stage and into the regulatory stage. But we've tried to touch it all. It's going to go fast. Hopefully it's all in your outline, so you're going to take that away with you. And with that, I'll get started. So we're going to cover the U.S. Supreme Court, federal court decisions, Michigan decisions, legislative and regulatory updates for both state and federal agencies, and try to give you an idea of what to look out for, which is a lot. So the U.S. Supreme Court continues to consider critical questions that implicate labor and employment law. They're off to a slow start. There are some important issues that they're going to consider this term, and the cases have started to be heard, but we haven't seen a lot of decisions rolling out yet. They're looking at affirmative action in college admissions, state legislative control over elections, the intersection of free speech and anti-discrimination laws. They're looking at, with respect to businesses, where they can be sued, what they can be held liable for, and how they communicate with their attorneys. In the last day or so, it was either Tuesday or Wednesday, they heard oral arguments on a case dealing with religious accommodations and religious discrimination claims. And the issue that they are considering in that case could and probably will impact other accommodation cases. They're considering whether to change the standard definition of undue hardship. Currently, if a person asks for a religious accommodation, the employer has a pretty low bar that they can claim a de minimis cost for the business is an undue hardship. The Supreme Court is considering whether that de minimis standard is too low, and employers would have to prove further costs. So look out for that one, because again, that will probably transfer. There are other discrimination or accommodation type cases where de minimis is the standard, and that's what they're looking at in that case. They're also considering Title 42 immigration policies, student debt relief, voting rights, and LGBTQ rights in this term. So the Sixth Circuit, I think we've talked about this before, they are really trending pro-employee with a few cases that have come out in favor of the employer. But the last few years, there's been quite a switch at the Sixth Circuit. It's becoming much more liberal. So the first case, Haley Hrdlicka versus General Motors. This is kind of an unusual case, but it's notable for the employer. This woman was a 30-year employee. She was terminated for poor attendance after she was transferred to a department she didn't like. She was off for a leave for a long time, came back. Her former job had been taken. They transferred her. She didn't like the new department. She ended up being terminated, and after she was terminated, they attributed her attendance problems to a brain tumor and persistent depressive disorder. And she sued GM for terminating her for a disability. The court held that the key inquiry is whether the employer made a reasonably informed and considered decision before taking an adverse employment action. Here, they went through the interactive process. They followed their attendance policies. And so the court held for GM, and it's really logical because she didn't come back with the explanation for her absences until after she was terminated, but good to see that the Sixth Circuit upheld that. The next case, Render versus FCA. This one is concerning, and I know many of you deal with intermittent FMLA, ADA issues frequently, and intermittent leave is really, really difficult to handle. In this case, the Sixth Circuit held that an employee with depression did not have to give formal notice whenever he called in to use intermittent leave after he got it initially certified. He had provided the initial FMLA certification. The doctor said he suffered from depression and would not be able to work when it flared up. He would call in and say he was sick. Sometimes he said it was a flare-up. The employer counted it towards his intermittent FMLA when he tied it directly to the depression, but other absences were counted as violations of the attendance policy, and the court said no. They were on notice that he would need this intermittent leave. It was enough that he gave it with the initial certification, and the employer should have figured it out. So be aware that that's out there. In Bennett versus Hurley Medical Center, the plaintiff was a nursing student. She had an anxiety disorder. She got placed at Hurley Hospital to do an internship and requested a reasonable accommodation under the ADA to allow her to bring her service dog into the hospital on her nursing rotations. The hospital initially granted her accommodation request and let her bring her dog, but the dog caused severe dog allergy reactions for both a patient and a staff member, and so the hospital withdrew the accommodation and told her she couldn't bring her dog anymore. She sued under the ADA and Michigan's Persons with Disabilities Civil Rights Act. The hospital position was that the accommodation caused a direct threat to the health and safety of staff and patients, and the court agreed granting summary disposition for the hospital. They noted that the hospital did go through the interactive process, and they reasonably concluded that the dog was a direct threat. So one important takeaway here, the court focused in part on the fact that the hospital went through the interactive process. That's key. You've got to do that in these ADA accommodation case or requests. The next case is very recent. Head versus Detroit Stoker came out of the Eastern District of Michigan on March 27th. The plaintiff sued under FMLA and the Worker Disability Compensation Act, claiming that she was claiming retaliatory termination due to her use of medical leave while she was sick with COVID and other complications. We're going to start seeing these cases. The company's defense was that they had finalized a company-wide reduction in force in early 2020, just before COVID hit. So they didn't implement it because everybody was remote, and then all the other things that went with COVID. The plaintiff went out on leave with COVID a year and a half later. They implemented it while she was on leave. Her position was terminated along with other people, and the court, they had evidence to show that they had this plan in place prior to COVID hitting and prior to her taking these leaves. And so the court granted summary disposition for the employer, saying that it gave non-discriminatory reasons for it, and they showed evidence of an economic-based company-wide reduction in force. But notable, they upheld it for the employer, but more importantly, I think that it shows that these claims are lurking out there and that they're going to become much more prevalent as we move forward. Levine versus DeJoy is an even more recent case, April 10th, out of the Western District of Michigan. And the plaintiff alleged that the post office discriminated against by failing to promote her on the basis of race. This was a long-term Postal Service employee, had served in a number of positions. She had significantly stronger qualifications in most of the categories that were being looked at for this position. A white hiring supervisor hired a white candidate based on the candidate's interview answers rather than considering job performance and qualifications. The person wasn't unqualified, but their qualifications did not rise to the level of the plaintiff. After the supervisor selected the white candidate, she then asked the unsuccessful black candidate plaintiff to train the person that they hired for the job. The district court granted summary disposition for the post office, on the basis that the plaintiff failed to demonstrate that the post office's justification for the hiring decision was pretext for racial discrimination, but the Sixth Circuit reversed. Again, very employee friendly. It held that the plaintiff offered evidence sufficient for a reasonable juror to conclude that a reasonable employer would have found the plaintiff to be significantly better qualified for the job. The Sixth Circuit also discussed the subjective nature of interviews and how they can provide ready mechanisms for discrimination. So the takeaway from that one is be sure you have objective reasons for making a choice. You can't base it all on the subjective presentation at an interview. Since we put this together, there's another Sixth Circuit case that recently was decided that is interesting and kind of a warning to employers. It's Millman versus the Feiger Law Firm. And in that case, an attorney asked for FMLA to take care of a sick preschooler who had COVID. It was right at the beginning of COVID. And instead of giving her leave, they fired her. And this case has gone up and down in the appellate courts, but the takeaway from the Sixth Circuit decision is that even if the attorney was not eligible for FMLA leave, the fact that she asked for it activated the FMLA protections against retaliation. So she asked for it, she wasn't qualified to get it, but because she asked for it, she was protected from retaliation, and the fact that they fired her was retaliatory. So keep that in mind. If someone asks for FMLA and they're not entitled to it, they don't meet the qualifications yet, they still have some protections. And now Rhonda is going to go through some Michigan cases for you.
Thanks, Laura. As has been indicated, and as you're learning from this hour, there has just been a flurry of recent activity, both in the courts and in the legislature, concerning issues that impact the employment circumstance. One of the things that we'll talk about is the fact that the Elliott-Larsen Civil Rights Act now prohibits gender identity discrimination. And the courts have also made a ruling that the Paid Medical Leave Act, minimum wage, and tip credit could dramatically change based on this ruling that we're going to talk about a little later in this hour. And then there's also been a lot of legislative changes, such as the right to work repeal, the consumer protections that are being instituted for online purchases, and then issues related to service training animals. We've seen an increase in the number of people requiring service animals as a result of emotional and mental health issues related to COVID and the pandemic. So these protections are meant to address kind of an increase in that circumstance and provide for training. So the first case that I'm going to talk about is Miller versus Michigan Department of Corrections. This is a case where certain corrective officers had friends that were complaining about civil rights issues, and then the claim is that because they were complaining, the friends were terminated. So we've got issues relating to whether a third party that you're supporting or is seen as being related to you actually creates a claim under the Elliott-Larsen Civil Rights Act. And initially, when the law was first entered, you had to have engaged in the protected activity yourself. It was self-focused. And now they're claiming that this is broader, that the protected activity could be that you were terminated because another person, and in this case it was close friends, had engaged in protected activity, even though you personally didn't engage in the protected activity. At the Court of Appeals level, the Court of Appeals concluded that an employee has failed to state a claim for third-party retaliation, and that the federal third-party retaliation claims that we see under Title VII in the federal context didn't apply to ALCRA claims. And the Michigan Supreme Court has granted leave in appeal in that case to see whether or not it will allow for third-party retaliation claims. So obviously this has some huge impacts in terms of discrimination and retaliation claims in our workplaces. The next case is McMillan versus City of Kalamazoo. This is a case where the plaintiff had filled out a job application initially and wasn't selected for the job. That initial application included information about a shortened statute of limitations period that we tend to see in some employment applications, limiting the statute as to certain federal and state claims to kind of give employers that finality in the event of a termination or a separation from employment. The plaintiff wasn't hired. About a year later, the employer reached back out to this plaintiff and said, hey, we've got this new position. Are you interested? And hired her for this new position, but she did not have to fill out a second job application. They just brought her back based on the first. So, of course, there was a dispute, and then when she tried to file a claim, there was an issue about whether or not the statute of limitations applied. And the court said, it was clear, the defendant's argument was that it was offering plaintiff the opportunity to apply for a job, and that offer was accepted by plaintiff when she filled out the application in the first place. But the court said, well, her application was ultimately rejected, though. And the question is, was plaintiff on notice that when she began the hiring process again a year later and went through the interviews and accepted employment, that she was still agreeing to be bound by her prior application? And the court found that there was a question of fact on this issue. And so that issue was required to go to trial. In comparison, we have the case of French versus Mid-Michigan Medical Center. Now, in this case, plaintiff had filled out a job application with a statute of limitations period in it. She had been immediately hired, but then decided that she wanted to transfer in Mid-Michigan health system to a hospital closer to her home. She had quit her job, she had come back, and then she was, as part of the second application, which she did a second application, she sought to transfer to this closer hospital. And they found that in that instance, she had never left employment. This was not a case, and in fact, she raised the McMillan argument, and the court said, no, this is not a case where you were hired and then, or never hired and now you're coming back. You never left your employment. You were always bound by the terms that you agreed to initially, and in the transfer request form that she submitted, she even affirmed that she was a current employee. So for those reasons, the court said, no, you are bound by the limitations. So the trial court granted summary disposition for defendant. The Michigan Court of Appeals has affirmed and distinguished the McMillan case. The court also refused to conclude that a limitations provision limiting your ability to bring claims under ALCRA violates public policy, which is what we expect to see. However, and again, this is just from March 23rd of 2023, 2 days ago on April 18th of 2023, a case that our firm is handling involving a workers' compensation case was up for appeal, and the Michigan Supreme Court just granted consideration of the appeal, asking for briefing as to whether the case correctly held the limitations clauses in employment applications are part of a binding employment contract, and whether the contractual limitations clauses that restrict retaliation claims under the Michigan Workers' Disability Compensation Act violate public policy. So what we're seeing throughout these spate of cases is the distancing and reining in of employers and what can be limited on employment applications and other types of agreements and arrangements. And we're also seeing a broadening of these civil rights kinds of cases that we see. When you talk about Doe versus Alpena Public Schools, for instance, this is one of those cases where maybe bad facts make bad law, but there was a student that was complaining that another student was mimicking sexual acts on her leg, was quote unquote tickling her in inappropriate places. These were reported to the school administrators, and the claimants that they did not do enough to prevent it. The student was suspended. When he returned to school, he was assigned to a different classroom, placed in a separate lunch period. He's told he was to have no contact, and they did have the police investigate. He subsequently transferred to another school. But during this process, she said that she did still have contact with them. And in an issue of first impression, the court said that the school may be vicariously liable for those students' conduct because they didn't respond appropriately to student-on-student sexual harassment. And the court found that schools do exercise a measure of control over students such that they could be vicariously liable for a hostile educational environment due to the harassment that students are receiving from other students. So this definitely has the potential to open up significant liability in our public schools in particular, where there's not always enough control over potential student conduct. SP versus Lakeland's Golf. This is a case where there was a complaint about sexual assault. And the question was based on arbitration agreement. And the next couple cases I'm going to talk about are all relating to arbitration agreements. So we saw earlier that they're addressing and limiting employers' ability to control statute of limitations issues in employment applications. Now we're also seeing that they're reining in arbitration agreements and the types of claims and cases that can be curtailed, if you will, or forced into arbitration. So in this case, a bartender who was working at the country club claimed to have been sexually assaulted by another individual during the course of her work. And she wanted to file a case, and the club sought enforcement of the arbitration agreement. And the court reviewed the elements for a hostile work environment, which included that it interfered with the employee's employment, and that it created an intimidating, hostile, or offensive work environment, and that the elements concern the employee and employer. And the court found that it is clear from these elements and the case law that a claim for hostile work environment sexual harassment is a claim that requires there to be an employee-employment relationship, that the essence of these claims is employer liability. And so it was part of her employment relationship, so the claims were subject to arbitration. Plaintiff argued that She was not claiming a termination because the language of the arbitration was a termination, but she was claiming, in this case, constructive discharge, which the court found related to termination. She had several counts in her complaint, and it noted that most of those counts concerned involuntary resignation or constructive termination. And the court said to the extent there was ambiguity, as the law states, it's resolved in favor of arbitration. Siegel versus Resource Tech Corp. Again, this is another really new kind of case where plaintiff was complaining about a public policy claim. And we used to see these a lot when people would essentially blow the statute of limitations for a Whistleblower Protection Act claim, that they would try to shoehorn in a claim of a violation of public policy. They'd say that they refused or failed to violate the law, or that they were exercising their rights under a legislative enactment such as MIOSHA. In this case, plaintiff was complaining about asbestos being present in the case, in the workplace. And the court found that previous courts had held that a plaintiff could support a public policy claim based on the internal report to the employer. In this case, it's not that plaintiff went to MIOSHA or went to some outside entity. Plaintiff complained up to his supervisor. And the court opened the door for, or is at least considering opening the door for, public policy claims due to internal work environment. So a complaint to a supervisor would be sufficient to support a public policy claim if the employee was then subjected to an adverse action because of the alleged report. In doing so, the court noted, they said, we see no reason why limiting public policy claims to external reports would serve the welfare of the people of Michigan, especially where the Whistleblower Protection Act might otherwise preempt claims that involve reports to public bodies. So obviously, one of the takeaways to this is that it's very important to make sure that if an employee is making a complaint that could be construed as a violation of law, or something of that nature, it's important to document that. It's important to take steps to resolve that claim or to address that claim. And it's important to also document the steps taken so that when this ends up in litigation, as frequently happens, you have a basis to go back and say, look, we did take appropriate steps. And then whatever adverse decision you're making, whether it's a discipline or a termination, to make sure that those are adequately supported by a record separate and apart from anything to do with this internal claim. So in Stigall, an internal report was sufficient to state a public policy claim, and the Supreme Court remanded it on this issue for further consideration, even though it really wasn't raised or preserved in the appeal. They noted that plaintiff hadn't raised the issue and then proceeded to rule on it nonetheless. And so they are now looking at whether that is preempted by state or federal law. Fortunately for at least the defendant in this case, the appellate court on remand did find that the plaintiff's public policy claims relating to asbestos were really preempted by OSHA and or MIOSHA. So in that case, the employer was found not liable. And then in Rauschworld LLC versus the Michigan Department of Civil Rights, this is a case where an event center operator and a hair removal business actually sought declaratory action against the Michigan Department of Civil Rights because they continue to have these investigations of people's complaints. The event center operators were involved in a same-sex wedding, which they declined to allow, and also the hair removal also dealt with gender in particular. Now, up until this point, and this was last year's case, but it's still very pertinent to the issues that you hear about in the news today. Up to this point, under Barber, which was a former case, sexual orientation was not included in gender identity kinds of claims were not included in Elliott Larson's Civil Rights Act. And that was done based on the way the federal law was at the time. But the court noted that the law has changed since then, both at the Title VII level in federal precedent, and the federal precedents that were the basis for that decision were overruled. So they note that, you put it kind of in a straightforward way, because sexual orientation is generally determined by references to the person's own sex. For example, if you have a female attracted to a fellow female, that's considered homosexual, but the same trait in a male is considered heterosexual. So the sex of an individual is necessary to determine what the sexual orientation is. So they found that it was inextricably bound up with sex, and therefore is protected. Now, the court did have a caveat that whether the enforcement of the Elliott Larson Civil Rights Act would violate religious liberties on either the federal or the state level had not been adjudicated, and it wasn't part of this case. But based on Roush, transgender status is protected under the Elliott Larson Civil Rights Act. And if you haven't had enough of state law, I'm going to hand you back over to Laura.
Thanks, Rhonda. The last Michigan case we want to talk about is Mothering Justice. Probably most of you have heard this case. This is the case that could upend Michigan's Paid Medical Leave Act and the minimum wage and tip wage laws. In late summer, September-ish of 2022, a Court of Claims judge held that the legislature illegally amended those two acts. They were proposed as ballot proposals or ballot initiatives, got the votes, they were going on the ballot. So in September of 2019, the Republican legislature properly basically hijacked the two acts and passed them as state statutes, because if it passes as a a ballot proposal, it's very hard for the legislature to amend. So they passed them as is, and then turned around and amended both acts in the same legislative session. Various organizations sued, got to the Court of Claims judge. He said it was legit for the legislature to pass the ballot initiatives, but that it was illegal for the legislature to then turn around and amend them in the same legislative session. So he overturned the amendment that the legislature put in place and put back into place the actual ballot initiative language, which is significantly different from the acts that we have in place right now. He also put a stay pending an appeal, which he knew was going to happen. The Court of Appeals in January overturned the Court of Claims judge and said the legislature properly amended the ballot initiatives. It went up to the Supreme Court. Oral arguments were held in February. We're waiting for that decision. But if that decision is overturned and we go back to the ballot initiative language, the minimum wage will rise quickly to up to $15 an hour, and the tipped wage will disappear, and employers will not be able to take a tip credit wage. They'll have to pay everybody minimum wage at $15 an hour. And more significantly, I don't know if it's more, but also of extreme significance is the Paid Medical Leave Act right now only applies to employers with 50 or more employees, and you have to provide, with a lot of different rules, 40 hours of paid medical leave per year. it will change, and if it reverts back, it'll apply to employers of 10 or more employees. Between 10 and 50 employees, you'll have to supply 40 hours of paid medical leave a year and 32 additional hours of unpaid medical leave a year. If you have 50 or more employees, you'll have to provide 72 hours of paid medical leave. So keep your eye on that. We'll blast it out as soon as a decision comes out. It's out there and it's significant. So right now we're maintaining status quo with those laws, but there definitely will be a decision soon. So I think probably everyone has read and seen the path the legislature's on right now with Democratic control of both sides and the governor's office. So far, she's signed a bill restoring the prevailing wage. So if you're a contractor that gets state contracts, you have to pay the prevailing wage, i.e. union wage, on any project you bid. You're not allowed to undervalue the wages. The legislature has also repealed the right to work law. It took effect March 30th. No, it takes effect March 30th, 2024, and it reverts back. This was the law until a few years ago. People could opt out. People have been able to opt out of belonging to the union in a unionized workplace. Now they cannot do that. They have to pay dues and be part of the union. So on April 13th, which was last Thursday, 1 week ago, a House committee in the Michigan legislature considered a package of 16 bills, many of which will affect businesses and or employers. Some of them could have a dramatic impact. These are, again, in committee, but it's realistic to assume that a fair number of them, given the makeup of the legislature and the governor's office, are going to, in some form, become law in Michigan. There is, one of them is an Employee Fair Scheduling Act. If you are a chain business, which they define as 2 or more locations, there's a bunch of regulations in this proposed act, but basically, if you change or alter work schedules for your employees, you're going to have to compensate them for that. That's the takeaway from that one. But again, there's a lot more in that act, and we're just touching on the topics because they're so uncertain right now, and I don't know what it'll look like if it ever gets to a bill. We would address it again in another seminar, but be aware that Fair Scheduling Act is proposed. The next one is a bill to limit the use of independent contractors. To be an independent contractor, this one is attempts to mirror California law, which has the most progressive employee protections in the country. But even in California, there are opt-outs for certain criteria in certain businesses. The Michigan proposed bill has no opt-outs. Everyone would be bound by it. One of the key parts of it is you would have to meet all 3 criteria in order to consider someone an independent contractor. They would have to be free from control and direction of the business in connection with performance of the work. They have to perform work that is outside the usual course of the business. Business is business. And the person would have to be customarily engaged in an independently established trade or occupation. So keep your eye on independent contractor requirements. That's also, I think Rhonda's going to address it later, that's also being discussed at the federal level. Not that Act, but there's a lot of activity on the independent contractor arena. The next one is kind of crazy. You probably hear about this in the news. It's been going on in other states for a number of years, but there's a bill proposed that would mandate wage transparency, and it would allow your employees to request wage information for similarly situated employees covering a 3-year period. You wouldn't have to turn over the name of the employees, but the employer would have to identify the sex and seniority of the employees, their salary, their hourly wage, any bonus pay, and overtime pay. And the next bill is even more concerning. It's a companion bill, and it would make violations of the mandatory wage transparency bill a felony, punishable by 2 years imprisonment, fines of up to $10,000, or both imprisonment and fines for every violation of not complying with the mandatory wage transparency bill. The next one is a restriction on the use of non-compete agreements. It would restrict all businesses from obtaining non-competes unless the business provided the applicant written notice of the requirement, disclosed to the employee or applicant the terms of the non-compete, and displayed a poster of the bill's requirements at the work site. There is already a bill proposed at the federal level on this topic, and I got a news blast today that Michigan's Attorney General has joined in a lawsuit or I don't know if it's a brief or a lawsuit, to encourage the passage of the Federal Trade Commission rule. So we're going to see some kind of restriction on the use of non-competes, I think both at the federal and the state level. The Michigan Act would prohibit businesses from obtaining non-competes from low-wage employees. If you violate this one, it would be a civil infraction with a fine of $5,000 for each violation, and the burden of proof would be on the employer to show that they didn't violate the act. Again, these are all proposed, but it's out there, and so people are thinking along legislators are thinking along these lines, and these bills, probably none of them would pass in the form that they're proposed, but some form may. The next bill deals with the False Claims Act. It would authorize private plaintiffs to sue on behalf of the state and collect a bounty if there's a recovery. This one is kind of concerning. This House Bill 4393 deals with enforcement, and it proposes giving the Attorney General $5 million to hire 25 full-time employees to enforce independent contractor and payroll fraud rules and regulations. So they're going to get 25 new investigators to go out looking for independent contractor and payroll fraud violations. 4394 allows anonymous complaints regarding wage, benefit, and record keeping requirements. So anybody could call, make an anonymous complaint, and the Attorney General is going to have the manpower to go out and investigate and enforce. 4395 allows individuals to anonymously complain about violations of the minimum wage law. 4396 expands the Whistleblower Protection Act. This is concerning. Expands the Whistleblower Protection Act to independent contractors and prospective employees and protects them from adverse action. So they don't even have to be your employee, and they can make a Whistleblower Protection Act claim against them, against your business, if they're not hired or a contract is terminated. House Bill 4402 is another enforcement. It creates a felony schedule for mispayment of wage, fringe benefits, and record-keeping requirements. 4403 creates misdemeanor and felony provisions for mispayment of wage, fringe benefits, and record-keeping requirements if you have the intent to defraud. So one is if you just do it. The other one is if you intend to do it. 4404 changes penalties from 10% per year to 100% per year if you violate wage, fringe benefit, and record-keeping requirements, and increases civil fines from $1,000 to $10,000. And 4405 changes garnishment notice requirements. So again, those are all just in committee, but those are the kinds of things that are being looked at in Lansing, and more to come, but kind of scary. And I just wanted to kind of end the Michigan law section by reminding you that Public Act 339 of 2020 still is out there. That's the one that outlines the COVID-19 isolation and quarantine periods. It basically says follow federal, state, and local health guidelines. But the significant thing for employers is that it prohibits employers from taking certain actions against employees who don't report to work because of COVID. It also protects employees who oppose violations of the COVID requirements or report health violations related to COVID-19. So just remember, if you have employees who either are out sick with COVID, ask for time off to take care of family members with COVID, or raise concerns about COVID, this law is in place and continues to protect them. And with that, Rhonda's going to talk about some of the things going on at the federal level.
Okay, so I have to wonder at this point whether there's a special federal committee that puts together these acronyms. We have the Providing Urgent Maternal Protections Act, for short, PUMP Act, which is appropriately named. This expands the rights for nursing mothers. It is to allow for paid work. If you're working while you're expressing milk, there has to be a reasonable break time. This includes telework employees. There has to be places other than a bathroom. If you have less than 50 employees and it poses a hardship, you may not be required to meet the requirements for location. But other than that, you need to provide an appropriate place for a mother to express her milk, and if there's greater state protections that are offered, those state protections would still apply. So similar to the sexual orientation and transgender change under ELCRA, you may want to review your policies to make sure that you're allowing for these types of breaks and things. You may want to train your supervisors and to look at possible accommodations to fit both the transgender sexual orientation circumstance and the PUMP Act, but also the Pregnant Workers Fairness Act. Title VII already provided protections when there was a pregnancy that resulted in a disability. This expands that to include known limitations related to pregnancy, childbirth, and related medical conditions. So it's a little bit broader. It requires accommodations for pregnant workers and for these are intended to be temporary during the course of pregnancy, just like under the PUMP Act. The PUMP Act has a 1-year requirement. These are also intended to be temporary. The employee has to request. The employer may not offer. And this is applicable to businesses with 15 or more employees. Reasonable accommodations that you might want to consider would be going on light duty, having a safer position or perhaps closer parking, additional or longer or flexible breaks to allow for the pregnancy circumstance, allowing water bottles or food if you have a policy against allowing food or drink, changing workstations or devices to make them more friendly to someone that's in a state of pregnancy, or changing the uniform to allow for maternity clothes and changing body shapes. It can be changing the work schedule. They may need shorter hours or a later start time. Again, lactation needs we talked about also with the Pump Act, but it requires that a private space that's not a restroom be provided, allowing for doctor's appointments, bed rest, things of that nature. Employers are required to engage in that interactive process, just like we see under the ADA. And of course, like the ADA, you cannot discriminate or retaliate based on pregnancy or the request for this type of accommodation or for the need of this accommodation. Another act that's coming through is the Federal Secure 2.0. This is more of an accountant or a benefits circumstance rather than a legal circumstance. And what this is, there's new tools for employees to have additional avenues to save for their retirement. It allows for increased catch-up provisions that will increase with inflation. So now it's directly tied to inflation in the amount that you're allowed to contribute. It has auto enrollment for your 401k. An employee must actually proactively opt out of a 3% working its way up to 10%. It removes penalties for emergency withdrawals for a certain amount. It's a very wide, broad package. So I would really recommend that you speak with either your benefits provider or your accountant to follow up on potential options based on that act. And then again, we talked about before these arbitration requirements and restrictions. This is another kind of sphere of those, in that they're now going to prohibit the enforcement of pre-dispute agreements, requiring that sexual assault or harassment claims be arbitrated. Now, this is pre-dispute, not pre-litigation. It also will allow for class action if the employee decides to go that route, even if it's been previously waived or considered waived from arbitration. So these are obviously a bit of a concern, but the one thing to note is that they are not per se invalid. What it is it's at the election of the employee. So there may be circumstances where an employee, because of privacy concerns or because they want maybe a quicker resolution or a more cost-effective resolution, may decide to go forward with arbitration, but it can no longer be required through a pre-dispute agreement to arbitrate. The Federal Speak Out Act is very similar in that it likewise prohibits the enforcement of pre-dispute, non-disclosure, and non-disparagement clauses. Again, it's pre-dispute, not pre-lawsuit, so it doesn't take away your ability to try to resolve a claim with a non-disparagement or a non-disclosure clause in order to resolve prior to litigation necessarily, but it is something that you're going to want to be aware of and keep in the back of your mind when you're negotiating with employees on these issues. As Laura mentioned, the Federal Department of Labor is also looking at updating the test for who's going to be an independent contractor. The takeaway is that they're make it harder for employers to call people independent contractors because obviously if a worker is an employee as opposed to an independent contractor, there's a lot of lucrative employment taxes and situations that are out there for the government. So that's being addressed, and we expect to see a rule in May of 2023. The federal government is also looking at non-compete clauses. Laura talked a little bit about the state is looking at those also. Right now, the comment period has been extended to yesterday, it closed yesterday. If this rule passes, it's going to take effect in 180 days. So we're kind of looking at fall for this one. It would apply to express and de facto non-compete clauses, non-disclosure clauses, confidentiality clauses, or clauses that require employees to repay, things that have the effect of impacting employment and prohibiting employment. It will not forbid non-solicitation clauses as long as your clause is narrowly drafted. If you have a situation where you sold a business and your buyer wants to preclude you from opening a new business just down the street and poaching customers and things of that nature, there is still going to be some ability to address those issues. However, with respect to the larger portion, employers are going to be required to rescind existing non-competes, and you have to supply individual notice to both your current and your former employees about the fact that their non-compete clause is null and void. And this is going to preempt and supersede all inconsistent state laws. So you are going to have a single system, regardless of what Michigan does under what Laura had discussed earlier, if that moves forward. In McLaren-Macomb, the National Labor Relations Board issued a decision on February 21st, 2023. And I'll give you just a minute to get caught up, John. I'm a few slides ahead of you. Ooh, back one. Employers may not offer employees severance agreements that require the broad waiver of their rights under the National Labor Relations Act. The agreements at issue prevented employees from disparaging comments about their employers or disclosing the terms of the agreement. And we're close on time, so I'm going to turn it over to Laura for the final wrap-up.
Thanks, Rhonda. Just quickly, DOL is proposing the rumor on the street is DOL is coming out with new proposed regulations on the white-collar exemptions. They've been talking about it for several months. It's believed they're going to come out in May. The speculation is it's going to substantially increase the current salary basis, which is $684 a week or $35,368 a year. We think that's going to go up substantially. It may also require periodic salary increases for exempt employees. It might change the duties test, and it may increase the minimum wage. So keep your eye out for that one. Again, we believe the proposed regulations are due out in May, although they haven't specifically said that. EEOC puts out their trend, or has trends. They put out, I think it's another slide, but they have historically, especially through COVID and even prior to that, have a big backlog of cases, and now they have a bunch of new investigators who are just working to come up to speed, but they have made it known that they're going to be much more aggressive litigating in the future. So we are seeing an uptick in EEOC cases in our firm. I'm getting them up here. They're getting them into the metropolitan Detroit area, and they're pushing them to mediation, and a lot are settling, but if they don't, look out for litigation. We're seeing disability rights and medical leave cases are more closely scrutinized, especially with the COVID-19 and all the medical leave laws that are coming into play. COVID-19 effects are still being felt and processed. across the board. Mental health conditions are a source of claims. Long COVID cases are becoming a source. We get more intermittent leave issues, more requests for leave and accommodations. Hot bullet point for everyone I know is more demands for remote work. Even if it's a traditionally non-remote job, some of those people are requesting remote work. All of these issues require really careful consideration of FMLA, ADA. You must go through the interactive process and document every step of the way. You don't always have to provide the accommodation, but you always have to go through the interactive process. Basically, whoever drops the interactive process loses, whether it's the employee or the employer. EEOC's strategic enforcement plan, they put out there what they're going to enforce every year. They expanded the category of vulnerable workers to include intellectual and developmental disabilities, arrest or conviction records, LGBTQI individuals, temporary workers, older workers, low-wage earners, limited literacy or English proficiency. They're looking at the employers who are using AI to make sure those employers do not inadvertently screen for impermissible medical or disability-related information. They're looking at discrimination associated with COVID-19 and other threats to public health, as well as violation of the new Pregnant Workers Fairness Act that a lot of people don't even know is out there yet, and technology-related employment discrimination. They're also looking at overly broad non-disclosure agreements and non-disparagement agreements. The Crown Act is kind of a national trend. There is a bill proposed in Michigan, which is why I bring it to your attention. It stands for creating a respectful and open world for natural hair. The Michigan bill would, again, expand Elliott Larson, which is now this, I don't know, like an octopus with all these different arms out there. But it would expand Elliott Larson to prohibit discrimination based on hair texture and race-based hairstyles, including braids, dreadlocks, twists, and afros. Also, to be aware, the Biden budget proposal, I think it's somewhat unlikely that this will get through as proposed, but he's proposing that FMLA be paid. It would be government funded and administered by the Social Security Administration. Again, a huge cost there, so I don't know that that'll slide. He's also proposing allowing 7 paid sick days a year, which I believe would be employer funded, not government funded, and a 25% increase in the NLRB budget to increase enforcement, just like at the state level where they're giving the Attorney General $5 million to hire 25 investigators and enforcement people. The Biden budget proposes a 25% increase in the National Labor Relations Board budget to increase enforcement. So in closing, expect to see continued expansion of workers' rights throughout 2023. We're keeping a close eye on the paid medical leave and minimum wage provisions. Don't diminish illness, sickness, medical conditions, thinking they don't rise to the level to implicate ADA or FMLA or other leave protections. Make sure that you examine them closely and go through, document and have a consistent process if a medical issue lands on your desk. And, review your handbooks and your agreements for necessary updates, especially with respect to non-disparagement, confidentiality, non-compete, those types of things, because they're front and center at the state and national level. All right, that's it for today. Unless you have any questions, I don't know. Do we, John?
There are just a couple, and we do have just a few minutes left, so we'll try to tackle those real quickly. The first one basically is for the case that you cited about the FMLA and an employee who was not eligible. How should employers handle a leave request? Should they still grant a leave regardless of FMLA eligibility?
Well, they might have to, but what happened here is she asked for FMLA and they fired her. So yeah, you'd want to go through the interactive process, sort of. It wouldn't technically in that situation be an ADA process, but you would have to look at your leave policy, see if she could use PTO, see if you have an unpaid medical leave of absence or a personal leave of absence policy. You know, that the firing immediately is a bad set of facts, but you run the risk of retaliation if you don't show that you considered all the options. It might be that the person ends up getting terminated, but it wouldn't be just because, you know, in that situation, it just looked like it was because she requested FMLA.
Right. Okay, thank you. The only other question I see right now is related to the Crown Act. And it's asking whether it covers people who color their hair, or is it natural hair that you were talking about? I think you mentioned natural hair.
I think there's various versions. It's intended to be natural hair, but I don't know if that's what it says. Yeah, it's just creating respectful and open world for natural hair is the acronym. And again, it's hard to say if that's going to come out of Michigan. It's proposed. Some states already have it. It's talked about at the federal level. I think it was, it died in last year's legislature, but I wouldn't be surprised to see it reproposed, and that's why I bring it up. I don't think it's intended to protect people who, you know, dye their hair every color of the rainbow, but I can't say that
Right.
for sure. It's out there. Be aware if someone doesn't meet your dress code standards. I guess I'd say look into it, but it probably, if you have an applicant or someone, that don't let that be the sole reason. You don't want subjective reasons for not giving someone a job. So stick to job requirements and qualifications when you make employment decisions.
Great. Thank you for that. Okay, that brings us to the conclusion of our program. I just want to run through a couple quick items with you all before you sign off for the day. You will get a survey when you sign off, so we would really love it if you take just a moment to fill that out. Literally takes just a minute or two. Your feedback is important to us, and then any topics you'd like to see us cover, we always take those to heart as well. So please take a look at that. The other thing I want to mention one more time is the continuing education. We do have the certification hours through HRCI and SHRM. You'll get that certificate in the next day or so. Just look for it in your inbox. If you don't need credit, you can just disregard that. The other thing I always like to do is just remind all of you that we do have a blog that is full of great information in real time. It's called our Sophisticated Employer blog. You can check that out by going to the Insights tab on our website, which is plunkettcooney.com, and you can work your way through that material at your leisure. Again, in closing, the webinar recording should be up later today, unless there's any issues we have. So if you want to hear any portion of this again, you can check it out there and share that event page link with any colleagues who maybe couldn't join us today. And I am happy to say we got through all of that material right on time. So congratulations to Laura and to Rhonda. And on behalf of them both, thank you all very much for being here, and we hope you all have a great rest of your day. Take care.